Signing a contract sounds good and big, right? But are all people are eligible to enter into a valid contract? So, through this video only, we are going to understand the very essential that is necessary to make a valid contract. So, in my previous video, I have already discussed the very preliminary part of Indian Contract Act, its definition, what differs an agreement to a contract. So, in today's video, we are going to understand the very essentials that is necessary to make a valid contract. So, let's first have a quick recap on what a contract is. Contract is more than just an agreement. So it is more of an agreement. Earlier, what we understood in the previous video that an agreement may not be a contract, but in order to be a contract, there has to be agreement. It is a legally enforceable agreement that meets certain essential conditions. So it is legally enforceable. If the other party denies to pay the return, the other party has the right to sue him in the court because it is legally enforceable. According to Section 10 of the Indian Contract Act, an agreement becomes a contract only when it fulfills certain requirements. So, what the definition or the essential is given under Section 10. So, this point we have to remember if we are mentioning the essentials of a valid contract, then we have to add in our answer in which particular section we have these essentials. Let's have a quick point from this paragraph. All contracts are agreements, but all agreements are not contracts. So this is the very tricky question that every student feels stuck at, and you have to know how to answer this. In my previous video, I have already made it clear how you can answer these very questions. Let's move into the next point. Section 10 outlines essential elements for a valid contract. So under the Indian Contract Act, Section 10 defines what are the essentials that is needed in order to make a valid contract. Let's move into the essentials now. Two parties. So there has to be two parties. You cannot make a contract with yourself only. There has to be at least two parties or more than two parties. Then will be, there would be a legally enforceable contract. And the definition is given under Section 2A and Section 2B. For a valid contract, there must be at least two parties, an offerer and acceptor. And what we will say to the people who are engaging into a valid contract, the one who is offering, he has become an offerer, and the one who is accepting it, he will become the acceptor. As from acceptor, we can also call him as promisee. Now, offer and acceptance must be properly communicated. So, when this contract is happening, the offer and acceptance from both of the parties has to be clarified. You cannot use telepathy to talk with the party. You cannot think, oh, B is thinking that I would sell this, and B is thinking, oh, A knows that I want to buy his house. This doesn't work in this way. Okay, telepathy doesn't work here. You have to make it very clear what your intention is, what you are offering, and the other party also made it very clear whether he is interested in buying your property or not. Offerer Section A 2A and acceptor Section 2B. The definition is given under this Indian Contract Act. At least two parties are essential. As I said, at least two parties or more than two parties, then only it will be a valid contract. Communication is mandatory. As I said, telepathy is a big no here. You have to make it verbal and understandable to the other party. Let's move into the consensus-ad-idem. Let us first understand what is this meaning. Consensus-ad-idem means a meeting of minds. Both parties must agree to the same thing in the same sense at the same time. Identity of minds. Agreement must be mutual and clear. Example, A offers house 1, B thinks his house 2. No contact. So now let us decode it in the easiest manner possible. For example, A is thinking about selling his house, which is located in Mumbai, and B is also interested in buying house. Okay, but B is thinking that A is about to sell his farmhouse, which is located in Dubai. So there is a miscommunication happening. This cannot, happen while dealing a contract. So A has to make it very clear that okay, I am talking about my residence that is in Mumbai, not the farmhouse that I go in weekends to have a party. So this has to be very clear. There cannot be any scope for miscommunication. So this is the very meaning of consensus-ad-idem. Both parties must agree to the same thing in the same sense, same time. So now B, must get upset that yes, I was thinking about buying that farmhouse. Now I have to live with that, house in Mumbai. So can't help. This is the very uh, definition given in the Indian Contract Act. Now let's move into capacity to contract, section 11. Only competent person can enter into a contract. As I said in the very beginning, just because there is an agreement, there is a contract, are all people will be eligible to make a contract? No, there is a certain limit that has been given under Indian Contract Act, which has been given under section 11 of the Indian Contract Act. This includes those who are mature, of sound mind, and not disqualified by any law. So this is the very ground. Here, major means I'm not talking about the major that we have in Indian Army. So this major means 18 plus. The person who is entering into the contract has to be, above 18 plus. Then only he will be eligible to the contract. For example, if we see in schools, children are making contract or agreement. If you give me your pen, I'll give you my copy. So this there is an agreement also, but they are not eligible to make certain kind of agreement because they are not major. So now we will understand this through a case law. So this is a very important case law that you have to remember any cause if you are writing your answer on essentials of a valid contract. If you add this particular point, so there's probability your score will get higher. It is Mohori Bibee versus Dharmodas Ghose. Contract with minor is void of any initiator. This is the very judgment given in this case. Contract with minor is void ab initio. So what is the meaning of void ab initio? It is void from the very beginning itself. It is not like that it has been void in the middle of it. No, it is void from the beginning itself because both the parties are not compatible. Both the parties are not eligible to enter into a valid contract. Must be of sound mind, not disqualified by law. So this is the key point that we have extracted from this paragraph. Now let's move into the free consent, which is given under section 14. Consent must be free and not influenced by coercion, undue influence, fraud, misrepresentation, mistake. Now let us understand through simple examples. For example, uh, A is selling his garage. Okay, again I will go to A and B. To B, B don't want to buy it. Okay, A cannot put a gun on B's head by stating that if you don't sign in this agreement, I will kill you, because there would be, undue influence or coercion. You were threatening the other person to give his consent, which is not free. So the consent has to be free in order to enter into a valid contract. You cannot blackmail the other person. You cannot take his signed, misrepresenting your statement. For example, you are making a contract by stating that I am selling my house in which is located in Mumbai, and you have uh, sold your garage. So these are misrepresentation of your valid contract. So it has to be very clear for both of the parties. And the consent is very much important here. It has to be free. It has to be free from all the grounds that has been mentioned here. Now let's move into lawful consideration, which is given under section 2D of Indian Contract Act. Consideration is something in return. It must be lawful for a contract to be valid. So in order to make the contract valid, which is needed, the return is needed. For example, if I am selling something, I'm expecting to get the money in return. That is the lawful consideration, that I'll be considering the amount that I'm getting after selling the thing that I'm offering. No consideration, no contract. If there is no consideration, there is no contract. Can be past, present, or future. Must be lawful. The consideration that I'm getting must be lawful. For example, if I am selling my car, I cannot take consideration uh, drugs. If the other person is giving me drugs instead of money, I cannot take it because that is not lawful. Drugs is prohibited, so I cannot take that as lawful consideration. Exceptions, but it has certain exception that is given under section 25, that is love and affection. But sometimes what happen, out of love we give someone something, that is in the form of a gift. So in that case we cannot ask for consideration. So there is a this is an you know exception in this manner. Time bear dove, this is also an exception in this manner. Let's move into legal relationship. Contracts must create a legal relationship. Social or domestic agreements are not legally enforceable. So legal relationship is another essentials of a valid contract. Now let's move into lawful object. The object of a contract must be lawful. If it is illegal or against public policy, the contract is void. So if we are selling drugs, it is already prohibited. So this won't be, falling under Indian Contract Act, or if the parties denies to pay or offer the object, you can sue the person in the court because it is already prohibited. So you cannot enter into a contract with an object which is already prohibited. Forbidden by law, selling drugs is already prohibited. Defeat legal provisions, fraudulent or immoral injuries at public against health policy. Obviously, drugs is injurious to health. Example, restraint of trade, marriage, legal proceedings, wagering agreements, making bet on certain games, for example, IPL, or such other things, agreements to commit crime. For example, if A says that A offers B that if you can kill B, I'll give you 500 rupees. For example, Supari Dena that we say in Hindi movies. So, to hire someone to kill somebody. So this kind of contract is not eligible under Indian Contract Act. Now let's move into certainty of term. The contract term must be clear. Vagueness makes the contract pushable. So if you are offering someone, if the other person accepts it, their communication has to be very clear and precise. What you are offering, what you want in consideration, for what time period you are giving it. So all this kind of detail has to be communicated with the other party. Clear, defined, definite terms required. Example, A offers 100 tons of oil, unclear what A was thinking of offering 100 tons of oil. So B was thinking it would be a coconut oil, but A was offering, what do I say, Nutella, not Nutella, what do we use, Safola oil. So this communication is, not clear. So this makes the contract vague, which is not applicable. Case Taylor versus Pottingon vague conditions contract void. This is the very case that you can refer while mentioning certainty of term, where it has the judgment was given that vague conditions makes the contract void. Possibility of performance. This is another essentials of this contract. The contract must be capable of being performed. If performance impossible, the contract is void. Okay, let's now understand it with another example. A has a girlfriend called B. Okay, A promises B that if you say yes to me, then I'll bring stars for you. I'll bring stars, I'll bring moons to you. Is this really possible to bring stars and moons to the person from the sky? No. So here, what is impossible? The contract is must be capable of being performed. You cannot perform the act, or you cannot perform the contract. So this, is a very vague statement that A is making to be out of love, passionately, romantically. I'll bring stars and moons for you if you say yes to me. That is not gonna happen. You cannot bring stars and moon. So this is a very small example that I'm trying to give in order to make it more, simple in your head. Impossibility void contract. So the contract is already void. So if you can uh, have that girl with some other tricks, try, but this will not do this star and moon thing. Legal and practical feasibility needed. Example, constructing a building in today's impossible. So this is another example that I have stated here. Constructing a building in today's, which is again impossible, because in order to construct a building, it takes time, it takes drawings, it takes all kind of, you know, uh, detail. So this is possibility of performance. That is another essentials of a valid contract. Now let's move into the last part of this video. So in this video, I have tried to add all kind of essentials of a valid contract. If you still have any queries, you can comment your queries in the comment section. I'll try my best to solve them as soon as possible. Soon we'll be meeting soon with another video. If you find this video worthy and worth watching, please like, share, and subscribe so that I can update with more legal information. Till then, stay happy, stay healthy. Thank you for watching the video.